was properly constituted to consider the impeachment motion, whether the nomination of His Excellency Kindiki could take place in the absence of fully constituted IEBC, and whether his nomination as Deputy President was infirm. We shall address these issues in turn. The third petitioner, Honorable Jane Njeri Maina, invited this court to declare that the National Assembly, as presently constituted, was not legally constituted for failure to comply with the constitutionally two-thirds gender principle under Articles 27, 81B, 100, and 261 of the Constitution. She submitted that, as a consequence, the National Assembly is incapable of entertaining or deliberating on the impeachment motion against the Deputy President. She therefore sought declarations impugning both the legality of the National Assembly and the validity of the proceedings arising from its resolution. The respondents opposed that contention. The National Assembly and its clerk maintained that the constitutional requirements concerning the composition of Parliament under Articles 97 and 98 of the Constitution had been satisfied. They admitted that they submitted that the two-thirds gender principle did not render Parliament unlawfully constituted or incapable of functioning, and that Article 261 itself establishes the constitutional mechanism for securing compliance where legislation or implementation has lagged. They warned that acceptance of the petitioner's proposition would invalidate all parliamentary business undertaken since 2013, an outcome they described as constitutionally untenable and absurd. The Speaker of the Senate and the Senate associated themselves with that position and further urged judicial restraint, submitting that despite that the dispute concerning implementation of the two-thirds gender principle remains actively before a duly constituted 5-judge bench in Conchela and others. There can be no controversy that the two-thirds gender principle is a constitutional imperative. Article 81B decrees that not more than two-thirds of the members of elective bodies shall be of the same gender. Article 27 and Article 100 reinforce the constitutional commitment to equality, inclusiveness, and equitable representation. The courts of this country have consistently affirmed that gender principle is not ornamental constitutional rhetoric, but a binding constitutional stance that demands implementation. Equally, however, constitutional adjudication must be undertaken within the framework of the Constitution and the dispute resolution mechanisms it establishes. The question before us is not whether the two-thirds gender principle is obligatory. It undoubtedly is. Rather, the narrower and the more immediate question is whether the alleged non-compliance with that constitutional principle rendered the National Assembly illegally constituted as to deprive it of authority to entertain and determine an impeachment motion under Articles 145 and 150 of the Constitution. Article 261 of the Constitution speaks to the timelines within which legislation ought to be passed by Parliament. It also provides for the consequences of failure to pass legislation. On such a failure, a petition may be filed in the High Court, and the court may grant a declaratory order directing Parliament and the Attorney General to take steps to ensure that the required legislation is enacted within the period specified in the order, and to report the progress to the Chief Justice. In the event Parliament fails to enact the legislation in accordance with the court order, the Chief Justice shall advise the President to dissolve Parliament, and the President shall so dissolve Parliament. The new Parliament shall then enact legislation within the terms contained in the court order, lest it faces similar consequences. The issue of failure by Parliament to enact the legislation on the gender rule has been litigated in courts for relatively long. Further, in an advisory opinion filed in the Supreme Court, other petitions under Article 261 have been filed in the High Court and declarations made. The Honorable Chief Justice even advised the President to dissolve Parliament. It was that advice that elicited the institution of Conchela and others versus Chief Justice Supra. The matter was recently determined by an expanded bench of this court via the judgment delivered on the 5th of June 2026, that is last Friday, where the advice to dissolve Parliament by the Honorable Chief Justice to the President was declared unconstitutional and subsequently quashed for failure to comply with some fundamental procedural steps. The court, however, clarified that the parties were still at liberty to comply with the requisite procedural steps, and that which the law will then follow its course. Therefore, as long as the redress in Article 261 is yet to be fully realized, it will be premature for this court to declare that the National Assembly was not properly